Moriarty.
May it please your lordships, I appear with Mr McNabb on behalf of the Revenue, instructed by the Mr Rabinovitz, Mr Hitchmo and Mr Jones, instructed by PricewaterhouseCoopers, appear on behalf of the Investment Trust.
Thank you.
As your lordships will have seen, we are each appellant and respondents.
Yes.
Before this court are two related appeals which raise a number of questions about the extent, if at all, to which a common law cause of action in unjust enrichment can be relied upon in order to give a claimant a monetary claim for repayment of value-added tax from a third party, the revenue, when the claimant mistakenly paid that money to somebody else, his own supplier, and in circumstances where the person who did pay the money to pay VAT to the revenue, the supplier, cannot recover it, as is of the operation of statutory code. The claimants, as you'll have seen, are closed-ended investment trusts. The suppliers were the managers who provided them with management services, and the statutory code, which prevented the managers from recovering all of the VAT in question for the revenue, was Section 80 of the 1994 Value-Added Tax Act. We'll need to take a look in more detail at the provisions of Section 80, because as your lordships will have seen, one of the issues before the court is whether or not one subsection in that section excludes a common law claim, even if it arises. But can I just briefly summarise the 5 points which we submit are important to note about Section 80? First, it provides a statutory mechanism by which a supplier who has accounted to the revenue for VAT output tax, which was not due, can recover it. And the reason why it's the supplier who has to make the claim is because it's the supplier who is legally liable to account to the revenue for that in the first place, regardless of whether he passes it on to his customer. Very important point to which I'll return. Secondly, it contains a provision giving the revenue a defence to a claim under Section 80 if meeting the claim would unjustly enrich the claimant. And that's to cater for the situation where the supplier has passed on the VAT to its customer. In effect, the operation of that provision means that the revenue can require the supplier to reimburse the customer as a condition of being repaid under Section 80 if undue VAT has been levied. Thirdly, it contains a set-off provision which has the effect, amongst other things, of allowing the revenue before making a repayment of undue VAT output tax under Section 80 to set off any VAT input tax that the taxpayer has deducted in relation to those supplies. Fourthly and critically, at the material time, it contained a 3-year limitation period. It's now 4 years, but the material time it was 3-year limitation period, requiring a claim for recovery of undue VAT to be brought within 3 years from the end of the prescribed accounting period to which the claim related.
Yep.
And fifthly and finally, Section 80, subsection 7, contains an express provision exempting the revenue from being liable to credit or repay any amount accounted to them by way of VAT that was not VAT due, except as provided by the Section 80. And it was against that background, as you have seen, management services which the managers had been providing to the investment trusts over a number of years had been treated as subject to VAT. When it turned out, as a result of European decision, that they should have been treated as exempt from the 1st of January 1990, claims were made by the managers under Section 80 of the VAT Act against the revenue, and subject to 2 caveats, the revenue repaid the undue VAT in full, which, pursuant to Undertakings Act to give to the revenue to stop them being unjustly enriched, they then passed on to the investment trusts in turn. But it's the 2 caveats which lie at the heart of this appeal, because they explain why the investment trusts want to rely upon a direct cause of action at common law against the revenue in unjust enrichment. The first caveat is, because of the 3-year limitation period, the revenue did not reimburse the managers VAT that fell inside the limitation bar. Now, your lordships may have seen that the way in which the limitation period worked in this case is slightly complicated. I'm not sure whether ultimately the precise detail are relevant to the issues, but in effect, because of the circumstances in which the 3-year limitation period was first introduced without transitional provisions, it was ultimately held that it was unlawful to have introduced the 3-year period without transitional provisions. The effect of that was that the provisions were made in 2008 to disapply the 3-year period in relation to claims that had accrued before the 3-year period was introduced. And so what you get is, you get this bizarre sort of limitation sandwich. You get the position where, in relation to all accounting periods ending before the 4th of December 1996, there's no time bar claim at all. In relation to all accounting periods ending within 3 years of the claim being brought, there's no time bar either. But the period in between those two periods is basically dead meat in the sandwich.
Right, what was the middle one?
The middle one is in relation to all accounting periods ending within 3 years of the claim being brought.
Yes.
And so it's the period in the middle which constitutes the dead period. But in a sense, although you can get all these details from the judgments below, the precise details aren't material to the question before the court, which is, in principle, can you allow a restitution cause of action to give the investment trusts reimbursement for that period in circumstances where the statute prevents the people who paid the VAT to the revenue getting it themselves?
So the statute replaces a 6-year limitation period that the common law would apply so far as the managers are concerned, and the issue is whether the consumers can take advantage of a 6-year limitation period.
Yes, in fact, precisely. Before the 3-year limitation period was introduced, the section did contain a limitation period that effectively tracked Section 32(1)(c of the Limitation Act 1980. The second and more simple reason why the managers were not able to recover everything from the revenue is that in the course of providing the supplies, they had been deducting input tax themselves from the supplies that they themselves were given by their own suppliers. And therefore, because they had been deducting input tax when accounting to the revenue for the output tax paid them by the investment trusts, when it came to reclaiming the VAT, because of the set-off provision I mentioned briefly, the revenue were only required to repay the balance. And your lordships may have seen that for illustrative purposes, the way in which it's been argued throughout is one assumes a notional £100 of output tax paid by the investment trusts to the managers. One assumes a notional £25 of input tax, which the...
Yes.
Yeah.
Well, and the input tax would be on anything they engage, secretarial services, ink cartridges, or whatever else they need as managers to operate.
Yes. That's right. And so, as a result of receiving £100 of output tax from the investment trusts, but being entitled to deduct £25 as a result of paying VAT to their own suppliers, the amount of money that's paid over to the revenue is £75, albeit you account for 100.
But would that 25% have found its way back to the revenue via the suppliers of the suppliers?
Well, what happens is the suppliers of the managers, they will account to the revenue for output tax, but they can deduct input tax. And then it's passed on.
I'm just saying there's a sort of diagram at the end of the Court of Appeals
Yes.
judgment. I mean, we may come to it later, but it's just sort of I always find it quite difficult getting the sort of circles clear in my mind on these things.
Yes. As you'll see, one of the issues,
Page 278.
the measure of the enrichment issue, we will require to go into some detail, but it's best if I leave that until we deal with the issue in detail.
And as matters have turned out, am I right in thinking that the managers should not, in accordance with EU law, have had the benefit of the deduction of input tax,
Yes.
which they actually received?
Yes.
So they are actually better off by the £25 as compared with the situation they ought to have been in if our tax law had been in conformity with the VAT directives.
Yes, and that's why our simple case on the cross appeal is that because the managers have £25 that they shouldn't have had, you can't say the revenue's enriched as the £25, it's the managers, and therefore the claim by the investment trust should be against the managers.
Yes, as you go up the supply chain, the revenue got the 25% from the suppliers of the managers, and the only extent of enrichment, you would say, that occurred when the managers accounted for VAT was the 75%.
Yes, exactly. Yes. So, against that background, as you've seen, there are 4 issues. The first issue, which is given in the Statement of Facts and Issues, is in fact the issue that's raised by the appeal of Mr. Rabinovitz. And what we're proposing to do is I'll open my issues in the appeal, and he'll open that when he opens his...
So you'll deal with issues 2 to 4.
Yes.
He'll then deal with issues 2 to 4 and 1.
Yes.
And you'll then
That's
reply,
right.
and then he'll reply.
And I think that works, my lord, partly because of
Fine.
the way we've structured our
Quite.
cases and partly because it's a relatively discrete issue.
No, that's fine. Thank you.
Can I then turn to the enrichment at the expense of issue?
Yes.
The first issue of my appeal. As you'll have seen from our case, the question of whether, and if so in what circumstances, a claimant has a cause of action against a third party on whom he conferred no direct benefit. And the more specific question, which is the question usually asked to answer that question, can the enrichment be said to be at the expense of the defendant, has been a very controversial issue amongst restitution scholars for a considerable amount of time.
Like a large number of other issues
Yes.
on restitution, yes.
Quite
Almost
so,
every
my lord.
issue in the law of restitution.
Quite so. But until relatively recently, they'd had very little to go on because there was not an awful lot of case law in this area. But then suddenly, like London buses, along come a number of cases all at once that address this problem. Not all at once, in the past 3 years. And they are all somewhat self-referential. So you get Mr. Justice Henderson's decision in this case, which was handed down in March 2012. You get the decision of the Court of Appeal in Menelaw, which discusses Mr. Justice Henderson's decision, which is handed down in July 2013. You get the Court of Appeal decision in Relford and Varsani in March 2014, which again discusses Mr. Justice Henderson's decision at first instance. You then get the decision of the Court of Appeal in TfL in 2014, again discussing Mr. Justice Henderson's decision in the decision below. Then you get the decision of the Court of Appeal in this case in February 2015, which considers Mr. Justice Henderson's discussion in the light of all the Court of Appeal cases going before it. And then finally, and most recently, you get the decision of this court in November 2015, which considers again Mr. Justice Henderson's decision in the case below and notes the approval's observations in TfL and in Relfo. Now, what I was proposing to do, therefore, given that we've got so much recent authority that in a sense moves things on from where things were 5-6 years ago, was, unless you'll all find this unhelpful, to take you on a whistle-stop tour of those authorities to see what they suggest about when a benefit received by a third party can be said to be at the expense of a defendant. And then having done that, make some submissions, which I think can be fairly short in the light of having gone through the cases, make some submissions as to why the law hasn't gone as far in my submission as extending a claim in unjust enrichment to the investment trusts on the facts of this particular case. Now, can we start, therefore, with the decision at first instance of Mr. Justice Henderson, which I can deal with very quickly because you won't need to have the facts explained to you, obviously, and I'm sure you've had an opportunity to read the judgment itself.
Thank you.
The judgment is at
305, yeah.
307.
Yeah.
And where we need to go to pick up the unjust enrichment at the expense of issue is paragraph 48 at 320. And at paragraph 48, the judge starts by dealing with Mr. Rabinowitz's submission,
Yeah.
who, relying upon what's said by your lordship, in my Lord Newburger in the University of Sussex case, which we'll come to, and also the decision of the European Court in Elida Gibbs, uses the analogy of the taxable person effectively collecting VAT from the customer on behalf of the revenue. So the role of the manager was to act as tax collector, and they're merely conduits. And he refers in that context in paragraph 49 to the decision of the European Court in the Elida Gibbs decision that my Lord Newberger referred to also in the University of Sussex. But then an important passage over the page at 322,
Yes.
he says that he's satisfied that there are dangers in pressing this point too far because the final consumer is not, in any ordinary sense, a taxpayer vis-à-vis the revenue. It's the supply of goods or services to the final consumer which triggers the liability to pay and account for VAT on the supply. And the supplier is liable accordingly whether or not he passes on the tax charge to his customer. Critical point, which I'll return to when we deal with the question of causation. Conversely, the customer is under no liability to the revenue for the VAT, even if the supplier pays for it, and the customer's obligation to pay the VAT to the supplier rests only in contract. And then it goes on the sentence after that. Essentially, for these reasons, I am not happy with the claimant's conduit metaphor, which suggests that the tax flows from the final consumer to the revenue, and that the supplier is in some sense acting as the customer's agent in paying it to the revenue. It needs to be clearly understood that the liability of the supplier to pay and account for output tax is a primary one, and in legal terms, the taxable person is the supplier, not the customer, and there's no relation of agency or anything resembling agency. My Lords, we really do stress that point and interpose, for example, that even now, in the investment trust's respondent's case, they still not only talk in terms of tax being collected by the state through registered intermediaries, they go so far as to say in paragraph 20 of their case that the legal responsibility to collect VAT from the investment trusts rests with the managers. That is simply not right. There is no legal obligation under the VAT Act for a taxable person to pass on or charge VAT to the customer or to collect it from the customer. It may just be that that's what happens in most cases. He goes on then at 52 and 52 to 50.
So is the short point, it's not merely the supplier is not simply accounting for the customer's tax. The supplier is paying its liability to pay tax, created by the fact that it is sold on to an ultimate consumer.
The minute it produces a supply,
Yes.
that's what triggers the obligation.
And the obligation is on it to pay, not to account.
Yes.
Elijah Gibbs explains how it should work if everything works according to the book.
Yes.
It accounts in the sense
There isn't a legal analysis of what the parties have to do. Sorry, I interrupted. I'm sorry.
it accounts in the sense that there may be input tax so that there's a set-off, but ultimately it's its liability.
Yes, and of course in the real world what will happen is in most cases when someone accounts to VAT, it's not as if it's a question of collecting the money and then passing it on. It will simply have maybe supplying services to a whole range of customers. It will then account on a block basis the revenue for all the output tax, and it will then collect in VAT pursuant to the terms of the contracts, which may allow an extended period of credit or not.
If your supply is subject to VAT, don't you, however, have to issue a VAT invoice to your customer against the possibility, at least, that the customer may itself not be the end user, but may be entitled to recover the VAT?
Yes.
So, I mean, that's missing from paragraph 50. The customer does have some connection with the VAT. It's not simply a matter for the supplier to decide whether or not to bill and to pay, or to bill to the customer. The supplier has to pay it, which is what paragraph 50 says in this judgment. But there is an additional element of having to issue a VAT invoice.
Yes, there's no doubt there's a connection in that sense, but it's not a question of the taxable person collecting that money as a registered tax collector or as an agent in any sense.
No. I mean, one can see that from the difference in the times at which you account and so on.
Quite so on. 52 and 53, he goes on to look at the views of the leading academics in the area. 55 to 59, he discusses, first of all, the decision in Kleinworth Benson, where there was an observation from Lord Justice Morritt that at the expense of was a requirement that the immediate source of the unjust enrichment must be the plaintiff. That's at 58. He then goes on at 60 to look at the Philby and Mortgage Express case, which is the first case that gives rise to looking at the thing from the point of view of reality. But then in the important part of his judgment is 67
Thank you.
and following, where he draws together the threads. He says there can't be any bright line requirement anymore that automatically rules out a restitutionary claim against an indirect recipient. He prefers to think of the position in terms of a general requirement of direct enrichment with exceptions. He then goes on in 68 to says that although you can't give a list of exhaustive criteria for recognising exceptions, there are a number of relevant considerations. The need for a close causal connection, the need to avoid any risk of double recovery, often coupled with a requirement for the claimant to be required to exhaust his remedies against the direct recipient, need to avoid any conflict with contract between the parties, and in particular to prevent leapfrogging. Leapfrogging is a concept, my lord, which was invented, a terminology used by one of the great restitution scholars, Professor Birks. And I'll go later on to what Professor Birks actually said about the significance of leapfrogging in a contractual context. And then finally, the need to confine the remedy to disgorgement of undue enrichment. He then observes in 69 that in this case, most of those particular considerations don't give rise to a problem. But critically, in paragraph 71, in 72, he deals with the one that he regards as being most problematic. He says, as is already pointed out, there is no strict causal connection between the payment of the VAT elements of the invoices and the payment of the VAT by the managers. And if you could read to the end of that paragraph.
Yes, well, he there refers to the invoices. Yeah.
Yes. But they're critically, the sentence which I do ask you to note is, it cannot even be said that the VAT was paid or accounted for to the revenue out of the money paid by the claimants and managers, or that the VAT would not have been paid but for the payments by the claimants to the managers. But despite that, and then going back to the Elida Gibbs
You have
principle,
to account for VAT if you haven't received payment.
and even if you haven't charged
Not
it.
once, even if you haven't charged it.
Yes. Yes.
Yes, I see. From the point of view of deduction, you have to have an invoice, but from the point of view of liability, you would just have to have supply.
Yes.
Is that all right? Yeah.
Yes, I mean, you cite the more recent criminal case in the Supreme Court,
Crown against Harvey.
which makes that point.
Yes.
Lord Reed and I, yeah.
But so dealing with the question of causation, he then needs to find a way of showing that there is a sufficient causal connection, notwithstanding that the VAT would not have been. It's not even a case that the VAT would not have been paid, but for the payment by the claimants of the managers, and he does that by going back to the principle that was discussed in Elida Gibbs in the Sussex University case, and takes the view that although as a matter of legal analysis, you can't say that the tax collector, the taxpayer is a collector of tax for the revenue. In economic terms, the person at whose expense the unlawful VAT is paid is the consumer. And therefore, he says, looking at it from the point of view of underlying commercial reality or economic reality, there is a sufficiently close causal connection. So can I invite your attention back to paragraph 65, which is where he gets his idea of reality from. Lord Justice May's reference to it in the Philby case. And he says, quite where the boundaries of this more generous version of reality should be drawn is unclear, but Mr. Rabinovich submitted that the claim in the present case fell squarely within the principle.
Yep.
So that's where we get the concept of economic reality being expressed so clearly for the first time. Let's then move on to Menelaus, which is page 1709 in the electronic bundle. It's in bundle 3 of the authorities at tab 41.
41, thank you. Yes.
The facts of this case were well known to my lords, Lord Neuberger and Lord Calmer, because you were both part of the Constitution. Very, very briefly and quite simply, in Menelaus, a bank had agreed to release 2 charges over the parents' homes, over the house of the parent, so that they could downsize and make a gift to their children of a smaller house, which they were going to buy. The house was to be owned by one of the daughters, Melissa, on the basis of her then granting a charge over the smaller house. But the charge ends up, for various reasons, being signed by somebody else, and not Melissa, and she claims that the charge is therefore void. And so what the bank seek to do is to recover the position by claiming to be subrogated to the unpaid vendor's lien over the house, on the basis that, first of all, it had a proprietary interest in the funds used to buy the new house, but, this is the importance of the case for us, even if it didn't, she'd been unjustly enriched at the expense of the bank. Because even if, strictly speaking, the money used to buy the house wasn't the bank's, the economic reality was that the bank released the money, which it would not otherwise have done so, in satisfaction of the debt on the parent's house, and released the charge over it. And that was a sufficiently close causal connection. Now, again, I'll try and do this as quickly as possible, but it is quite important to see, again, how economic reality comes in. The leading judgment is given in this case by Lord Justice Floyd, which starts at 1710. But we can pick it up at paragraph 35.
Thank you.
Paragraphs 34 and 35, he looks at the Philby case again, and in paragraph 36 observes that that shows again that the court will look to economic reality. Paragraph 37 is an important paragraph for reasons that will become clear when I make my submissions. He refers to the point, which is again referred to in the Supreme Court later on, that had the bank insisted on the repayment of all the outstanding indebtedness and relent the sums required to purchase Great Oak Court, that's the daughter's house, they would have been entitled to security by way of subrogation to the unpaid vendor's lien. To refuse a remedy in present circumstances was mere formalism of a kind rejected in the Banque Financière case. Then in 39 to 41, you can see he then refers to the judgment of Mr. Justice Henderson, which was looked at, describing as a thoughtful and valuable analysis of what's meant by being at the expense of the claimant, and quotes over at 1720, paragraph 67, where the judge had drawn together all the threads. And then, critically, at paragraph 42, having looked at what Mr. Justice Henderson said, he concludes that whilst the precise range of relevant factors which are relevant may require consideration in other cases, for my part, I would hold there was a sufficiently close causal connection in the present case between the bank's agreement to part with its estate in Rush Green Hall and the enrichment of Melissa to hold that the Melissa was enriched at the bank's expense.
Yeah.
And then when going on, interestingly, when going on to look at when he deals with subrogation, whether the remedy of subrogation should be granted given that he was satisfied that the receipt had been at the expense of the bank, you can see at the end of that paragraph, 48 on page 1723, having held that there was a transfer of value from the bank to Melissa, he applies the test of economic reality. The other two judgments are given by Lord Justice Tomlinson at 1724.
The loans remained throughout due from the parents in Menelaus, but the reality was that they were due from the properties.
Yes.
Well, they were secured on the property.
They were secured,
Yes.
Exactly, they were
Yes.
secured on it. So
They
the
should
only
have
way
been
they-
secured on the property.
The only way they were going to be recovered was out of the properties.
Yes, exactly. Because there was a negative.
That's why it's a transfer of
negative-
value to give the property
Yes.
without the charge. Yeah.
You're going to refer to the other two judgments.
I am, very briefly. Lord Justice Tomlinson, one can see, it's really paragraph 56,
Yes.
without the bank promising to release its charges over Rush Green Hall, the funds released on its sale could not have become available to be used in the purchase of Great Oak Court, and he holds that that is a sufficiently close causal connection. But it says over the page at 57, I do not see how this consent would be described as anything other than a transfer of value between the bank and Melissa. So he is seeing that as being a case of, even though not direct payment, transfer of value. I'll come back to that. Please note that. Note that he doesn't expressly, however, make any use or refer to an idea of economic reality in terms. If you treat formalism as opposed to formalism, if
Well,
you regard...
he agrees with Lord Justice
Yes,
Floyd.
yes, yeah, yeah. Contrary-wise, however, Lord Justice Moses, as you can see, is satisfied that there is a sufficiently close causal connection. This is paragraph 61, a sufficiently close causal connection, because Great Oak Court would never have been purchased and the obligation to pay its vendors would never have been satisfied had the bank not agreed to release its charges over the parent's house.
Yeah.
And he says at page 62 that he regards that a conclusion which you can reach without any need to invoke the somewhat fuzzy concept of economic reality. So that's Menelaus. Next, Relfo, which is in the same bundle at tab 44, electronic bundle number 1792.
Yeah.
Again, the facts of this are relatively simple. 2 months before going into creditors' voluntary liquidation, the director of the claimant company, Relfo, wrongfully caused £500,000 to be paid by Relfo into a bank account of a company in Latvia called Miran, so a Latvian bank account. On the same day, the Singapore dollar equivalent of £500,000 was paid out of a quite different bank account belonging to a different company in Lithuania, Intertrade, which goes into the defendant's account in Singapore, Mr. Varsani. And there is no evidence at all to show any transfer from the Miran account in Latvia to the Intertrade account in Lithuania, either before or after the payment to Mr. Varsani. When liquidators are appointed over the company, they bring proceedings in the name of Relfo to recover the £500,000 payment from Varsani on the basis of being unwrongfully paid out by the director. And they bring the claim on two bases. They bring the claim, first of all, upon the basis that despite the evidential difficulties, they can still, by inference, trace through the money to Varsani, and therefore they have a proprietary, they can trace through property, and they have therefore a claim in knowing receipt against Mr. Varsani. But alternatively, and again it's critical for this case here, they say that even if there's no tracing claim, there is a claim against Mr. Varsani because he was unjustly enriched at the expense of the claimant company, Relfo. The Court of Appeal held actually that despite the lack of evidence to show the money had passed from Miran to Intertrade, the judge had been right to infer for a number of evidential reasons that the source of Varsani's money was Relfo, and therefore there was a claiming knowing receipt by tracing. But that even if that was not right, in other words, even if they were not able to trace through from beginning to end, so as to have a knowing receipt claim, Relfo would have a claim in unjust enrichment against Mr. Varsani because he'd been enriched at Relfo's expense. And so clearly it's a case where you'll have a claim in unjust enrichment against someone who can't be said to be a direct recipient. Now, in this case, the leading judgment is given by Lady Justice Arden. We can go the second issue, which is the unjust enrichment issue, is dealt with starting at 1807.
Thank you.
Paragraph 70, the learned Lady Justice says, as explained in paragraph 26, the judge held that Mr. Bimji Varsani would not have obtained the intertrade payment but for the Relfo Miran payment. But for is a filter or preliminary filter which the law uses to filter out loss for which a claim for compensation will not succeed. But then she goes on in 72 to say but it's effectively common ground that liability in unjust enrichment requires more than a but-for test be satisfied where the claimant, as in this case, contends the defendant was enriched at the claimant's expense through the invention of third parties. And that's a point I want to echo later on in my submissions, that when you're dealing with the question at the expense of, but-for is a precondition of being able to satisfy the but-for test, but at least on the law as it stands at the moment in my submission, you need a further intensifying factor to establish at the expense of. And the difficulty, the problem that the courts have been searching for up until now is how you identify what that necessary additional intensifying factor is.
Yep.
74 to 76, the learned Lady Justice again refers to the work of the academics, including Professor Burrows.
Yep.
82 to 84, the reference and analysis of Miss Justice Henderson's decision in investment trusts in this case. In 86, you can then see that she refers to Menelaus and Lord Justice Floyd's conclusion that the appropriate test is one of economic reality. 90 to 91, reference to Philby. 92, she agrees with Miss Justice Henderson that reality which Lord Justice May was referring to was not confined to strict legal reality, but could in appropriate circumstances include a broader underlying commercial or economic reality. And then in concluding in paragraph 97,
Yes.
she says the judge found that Mr. Gretsch's objective, that's the director of RELFO, was to confer a benefit on Mr. Varsani by a circuitous route. Those factors are, in my judgment, the principal factors that make his enrichment unjust. In my judgment, they are sufficient for this purpose. As a matter of substance or economic reality, Mr. Varsani was a direct recipient. And then the other two judgments are shorter. There's a judgment given by Lady Justice Gloucester.
Well, just pausing before we look beyond that. So Lady Justice Arden's saying that this isn't. I mean, her test seems to be whether Varsani is a direct recipient.
Yes.
But she's treating that as a question of economic substance rather than of form.
Yes. In fact, your Lordship's quite right to pick that up. And in fact, the point can be illustrated when we look at my Lord Neuberger's judgment in Menelaus. Very often, the factors that are said to give rise to the sufficient connection are sometimes relied upon to show that they constitute a direct benefit. But alternatively, they say, well, but even if it's an indirect benefit, for the same reasons, there's still a sufficiently close connection.
Yeah.
Lady Justice Gloucester, initially reluctant to express a view given that she is happy with the tracing claim route, but paragraph 103, again, she says the arrangements that were in reality equivalent to a direct payment and demonstrate sufficient causal connection. Lord Justice Floyd...
But nobody's really... Is anybody tackling what constitutes sufficiency?
That's the point I'm going to be dealing with in my submissions, my Lord. It is a very important point. But before we start making submissions, it's probably best to show you the panoply of cases that your Lordship needs to grapple with in working out what the law is. Lord Justice Floyd, though, does actually give a rather fuller explanation, which in my submission is useful in analysing this case when we come to my submissions. He gives a slightly fuller explanation of why he's satisfied that there is a sufficiently close connection that is equivalent to a direct payment. And if you start at 115, he says he doesn't wish to attempt, because it's not necessary, an analysis of precisely how much liberalisation of a direct transfers only rule or how much tightening of a but-for test will ultimately prove to be appropriate. But in this case, the factual findings made by the judge in the present case made its conclusion that there was a sufficiently close causal connection, an inevitable one. Indeed, providing one focuses on the substance and not on the form, or as it's put in some of the cases, on economic reality, the facts in the present case show that the arrangement by which Mr. Goretti benefited, enriched Mr. Beamji Varsani, used Relfo's money, were equivalent to a direct payment. So there you've got a notion of equivalence to a direct payment. But if we go to 120 to 122, you can see what the evidence is that's critical in this respect. 120, Mr. Goretti explained to the Varsanis that he was arranging for the transfer from Relfo to the Varsanis. Then 122, the intermediate arrangements are therefore an elaborate facade to conceal what was in truth intended and arranged to be a payment for the benefit of Mr. Varsani. This was, however, more than mere intention involved. The structure put in place by Mr. Goretti made it inevitable that the payment would be effected to Mr. Varsani. And then 122, I cannot accept the suggestion that the intervening and meaningless arrangement orchestrated by Mr. Goretti, which had no other purpose than disguise the source of the funds diverted from Relfo, changed what would otherwise have been a direct payment into one which the law will not recognise as sufficiently proximate.
So he's looking to factual causation, and he's ignoring the fact that there may be two transactions.
He's saying in substance there was a transfer of value directly. It just happened to be rerouted through various channels for the reason of disguising what was going on.
Yes, so the channels are at worst a sham, at best a form of agency.
Yes. Certainly sham. Yeah, agency. What?
Well, conduit.
Yes. Yes.
Was there any difference between the facts which established, in Lord Justice Floyd's view, the unjust enrichment claim from those which established the tracing claim? I mean, basically, they were both based on the fact that there was effectively a conduit.
Yes. I suppose. I mean, I suppose in a sense, although analytically, you don't need to consider any at the expense of requirement for the purpose of the tracing claim, because once you establish a tracing claim, then
no, I understand that.
Yeah. But in a sense,
different. But actually, they're treated almost exactly the same.
The very same factors that convinced him that this was really a direct transfer of value, because the route it took was a sham, was the very reason also why he was convinced that the money that Mr. Varsani received, the Relfo money, was the source of the money that Mr. Varsani received.
It's the same money.
And therefore you can trace exactly what.
Yes, well, it was a breach of fiduciary duty by the director
To pay out.
and Varsani benefited from it.
Yes.
So in Scots law, the principle that you cannot profit from someone else's breach of fiduciary duty would have taken you to the same place.
Right. The next case is the TfL management case.
Yep.
Which is in bundle 4. Electronic document number 2124. Now, I take you to this case, obviously, for completeness, because it is one of the 4 buses that have come along recently. But my submission is that ultimately one doesn't get much out of this case other than to recognise the real dangers of unjust enrichment getting completely out of hand unless you keep a very tight grip on the at the expense of test. The reason why I say you don't get much out of it as a matter of law is because this was a summary judgment application, effectively to get rid of an unjust enrichment claim. And it's quite clear from the tenor of the judgments that they were very much influenced by the fact they didn't feel quite confident enough to suppress the claim at birth, and so they let it go to a full trial. But when you stand back and look at the facts, they are very striking indeed. What happens in TfL is this. An assignee of some contracts, as a result of being an assignee, believes it has a claim for commission against a company called Hesco, who'd entered into business relationships with the assignor. The assignee is called Explorer, so you know who it is when we go through the judgments, sues HESCO for commission due under those agreements and succeeds at first instance. They go on to the Court of Appeal, but HESCO continues to take 101 points about why the money isn't owed to the assignee, and HESCO wins on the basis that when you look at the actual terms of the assignment, there was a carve-out. And although HESCO owed money, they didn't owe it to Explorer, the assignee, they owed it to the assignor. And so the money that... So they've paid out £550,000 getting thus far, and they've ended up with no judgment, other than the judgment that says the money's owed to somebody else.
Right.
Of course, this is great news for the assignor and for the Lloyds Bank who have a charge over the assignor, because they say, well, we'll get the money then. So they sue the debtor and they pay up under a settlement, and the money then goes to Lloyds Bank. Now then someone, doubtless with a keen eye on the developing jurisprudence, actually comes up with a rather good wheeze. They say, well, the assignee who lost the original proceedings against HESCO has a claim in unjust enrichment against Lloyds Bank because Lloyds TSB had been enriched at the assignee's expense. They say the assignee spent £550,000 mistakenly pursuing a claim which they thought they had. It lost, but at least it produced a judgment that made life easier for Lloyds Bank. And the assignor benefited from that judgment because it was easy to pursue. And in those circumstances, what you might regard as extraordinary circumstances, the management service company over whom Lloyds TSB, who...
Gosh. They said that claim was pursuable.
Yes,
I see.
it was.
Mrs. Donahue would have had some
Yes,
valuable...
that's why I say this really does, even making allowance for the fact it was effectively a strikeout. This shows you the problems you get into and the potential floodgates.
If it'd been gone to trial and there'd been no snail in the ginger beer bottle, I think that's the point Lord Reed was saying under his breath. Miss Donahue would have recovered all her costs from subsequent claimants who would have been succeeded in their tort actions, which, but for her, they wouldn't have succeeded in.
Now, let me just show you briefly how we got to that state. Again, the leading judgment, once again, is given by Lord Justice Floyd, the proponent of economic reality. Now, paragraph 45 we can start with. The way in which it's been argued below and the way it was argued before the Court of Appeal was there's what's called an incidental benefit doctrine. It was said to be an incidental benefit doctrine in unjust enrichment, but whereby a benefit obtained by a defendant is sometimes said not to be the expense of another, even if directly obtained from him, if it's merely incidental to the purpose of the defendant unconnected with the other party's enrichment. And it was being said, well, the purpose of pursuing the judgment wasn't to benefit Lloyds TSB, it was to actually get the money. But Lord Justice Floyd, in paragraph 45, says that he doesn't actually think in the law of unjust enrichment the incidental benefit doctrine really tells us anything, really. He says that nowadays, the conceptual structure of restitution involves asking 4 questions, which he sets out in 46. Has the bank been benefited or enriched? Was that at the expense of the claimant? Was the enrichment unjust? And was the defendant entitled to a specific defence? And so he basically throws aside incidental benefit and says, I need to look at it through the prism of the 4 considerations. And he says at paragraph 50, when looking at it from the point of view, was there an enrichment? He says, I regard it as commercially unrealistic to suppose that TTF did not benefit from the Court of Appeal judgment. So he thinks it's arguable there's a benefit. Was the enrichment of the bank at Explorer's expense? It's at this point at 55. He then refers to the useful guidance in investment trusts.
But it has to be surely a benefit of the law.
And he rejects at 64 the suggestion that the claim has to fail on the ground there's an insufficient causal... He does not feel able to say that there is an insufficient causal connection based simply upon the passage of time, which is the way it was being argued by counsel for the bank. And he said that it also can't be said that the enrichment was not unjust when assumed facts were that both Explorer and Lloyds TSB thought Explorer was entitled to commission. And so you get the conclusion at paragraph 68, that on the assumed facts, it is possible for TfL to argue with some degree of conviction that Explorer conferred a real benefit on the bank, that the benefit was incurred at Explorer's expense, and it would be unjust for the bank to retain it. Lord Justice Beatson gives a concurring judgment where he says, well, ultimately there may be difficulties in valuing the benefit, proving the benefit, but I'm not prepared at this stage to say the argument is not tenable. So he again dismisses allows the appeal. Sir Stanley Burnton actually gives a dissenting judgment starting at paragraph 71. Right, so they are the the three Court of Appeal cases. That there then takes us, and we can deal with this quickly because I'm sure your Lordship sort of read the judgment with some care already. That then takes us to the fourth Court of Appeal case in a row, which is our Court of Appeal case that we're appealing against. And that, my Lords, can be found in the core volume at tab 12.2 at electronic bundle number 238.
Thank you.
And can deal with it very quickly, not just because you've read it yourselves already, because it really sort of follows the usual format now of the cases.
It's it strikes me at first blush as a very parochial approach being adopted here. Has nobody looked at case law from Canada, for example? It's quite a rich unjust enrichment jurisprudence, or Australia.
I think there has been. The trouble is, my Lord, that although these jurisdictions do recognise a law of unjust enrichment, the approach they take is very often, for policy reasons, very different. And so you can't directly analogise and say you get much help from what a case will say in Canada or what a case will say in Australia.
Why should the policy be different in Canada and Australia from what it is here?
Well, I mean, that's a good question, but
What's the answer?
I'll come back to you on that one.
Thank you.
But whether you call it unjust enrichment or, as in Scotland, unjustified enrichment, what is being aimed at is essentially the same thing. And I think it would have been quite interesting to have seen how Scotland or South Africa, for example, would have dealt with similar claims. Because if you're complaining that a whole lot of buses have come into English law at the same time to the bus stop, then I wonder if you're asking us to make a ruling focused on a rather narrow viewpoint. Certainly in a smaller jurisdiction like Scotland, we were encouraged by the late Lord Roger to look at English case law, not so much for how they achieved the result, but what the result was, in order to draw learning by analogy.
I mean, surely there's so many textbooks, treatments of this subject. They must have looked at the Commonwealth analogies, haven't they? I mean,
we'll go and dig some material.
I can't. I don't remember in Menelaus whether we were referred. I don't think we were referred to much outside the UK. But the odd if the people like Professor Burrows hadn't looked at anything relevant in those other countries. My recollection is that again, Professor Burrows. So much of this goes back from the way in which it's been looked at from one of the great restitution scholars, Professor Burks, and I mean although it's true to say he was obviously he was a great civil lawyer as well, Germanist in particular. Certainly in his sort of groundbreaking work on law restitution, a lot of it was concerned with trying to rationalise the English law by reference to arcane areas like usurping a public office and this sort of thing, and did a magisterial job. But I take the reproach
Well, it's not meant as a reproach. It was a commentary. It was just a comment about the cases we've been looking at.
Yes.
I mean, if it's being dealt with at this level, if there is relevant material in other jurisdictions, then well, speaking personally, I'd be interested to see it.
Okay, well, we'll go away and...
Because otherwise you're asking us to make a judgment on a self-referential coterie of cases,
Yes.
which I think is perhaps unhealthy.
Yes. Though, I mean, to be fair, a self-referential group of cases that have considered the work of the academics where they do tend to disagree with each other.
But it's also rather a small group of people.
Yes.
With family links to Professor Burke's.
Yes, I think we were referred in Menelaus to New Zealand and Hong Kong authority,
Right.
judging by the summary of the case. Anyway, yes. So you were taking us to the judgments in this case.
Yes, yes.
In the Court of Appeal.
And really it's at 42 it starts,
And Australia.
page 250. So it starts out again by setting out the famous passage from Miss Justice Henderson below. Refers at 48 to 50 to the older cases, the Kleinworth-Benson case.
Australia.
The Philby case at 50.
Yep.
Then at 52 to 64, you get the analysis, discussion of
Yep.
Menelaus, Relfo, TFL.
Yep.
And it's 67 where you get the conclusion,
Yep.
which effectively is to endorse what Mr. Justice Henderson has said, which is that there's a sufficient economic connection because the final consumer who pays the tax has a sufficient economic connection with the revenue to be able to say that they're enriched at his expense. So it's economic connection, so it's economic connection again, that establishes at the expense of. And although tempted, or possibly not tempted, but they certainly didn't do it, in paragraph 68, to try and give a more definitive answer as to when there is a claim against an indirect recipient and when there's not, they say there are too few concrete examples and cite Anne's and the Merton Borough Council, the Talk case, as being a case that shows you the danger of formulating a general principle before there is enough material upon which to rationalise the law. And then that leaves us finally, my lords, with Menelaus in the Supreme Court, which is back to volume 3 of the authorities, tab 42.
Yep. Yep.
Mr. Rivers wants me to read paragraph 69 of the Court of Appeal.
69, right. Before leaving this part of the
Yeah.
case, page 262, yep.
Sorry.
Should we read it to ourselves?
Yes.
Sorry, what are we reading?
Page 69, paragraph 69 on page 262 of the core bundle.
Sorry.
Yes, Mr. Rivers is quite right.
Yep.
Does anyone consider this point that while the consumer here pays 100 to the managers, the revenue receive 75 because of the input tax which the manager is entitled to deduct. Now the figure of 75 depends on the manager's business. It could have been 5, or it could have been 95. So the link between the 100 paid and the amount actually by which the revenue is enriched might be said to be rather tenuous.
Well, yes, I mean, I take your lordship's point. I think the reason why it may not be tenuous in one sense is that I would accept that if the VAT were validly due, if it were taxable, it wouldn't matter how much input tax was deducted for the purposes of working out whether revenue enriched. Because if the VAT was genuinely subject to, if the supplier was genuinely subject to VAT, so that the input tax was genuinely deductible, then the deduction of the input tax would mean, although the revenue hadn't received the £90 or the £25, whatever it is, it would have discharged the revenue's liability to the managers to effectively allow them the input tax.
But the premise doesn't hold, does it?
No, here the premise is that it's invalid.
Yeah.
Yes. And if the premise is that it's invalid, then I think your lordship's right. Whether or not the revenue is enriched, and if so, how much, depends upon the happenstance of how much input tax the managers are able to deduct or purport to deduct against their liability in relation to output tax.
Yes.
Yes, it's volume 3, tab 42. The two judgments we need to look at are those of Lord Clark, with whom Lord Carr and Lord Wilson agreed, and Lord Newburger, with whom Lord Carr and Lord Wilson also agreed. I mean, no disrespect to Lord Carnworth in saying we don't need to look at Lord Carnworth's judgment, because Lord Carnworth decided the matter on a basis avowedly not concerned with unjust enrichment, but confined to analysis to traditional subrogation analysis. There's nothing in there that takes matters further for these purposes. Let's start with the judgment of Lord Clark, paragraph 23.
Paragraph?
23,
Thank you so much.
729.
Yep.
He refers to Goff and Jones, pointing out that the law of unjust enrichment is not concerned with the disgorgement of gains made by the defendants, nor with the compensation of losses sustained by claimants, with the reversal of transfers of value between claimants and defendants. I agree. I ask you to note that concept of reversal of transfer of value, because that echoes a point I want to make when I show you an interesting contribution in this area made by a restitution scholar commenting upon this particular case. In paragraph 24, he says that the answer to the question whether Melissa was unjustly enriched at the expense of the bank is plainly yes. He explains why. Agreed to release £785,000 for the purchase of Great Oak Court in return for a charge on Great Oak Court. It was thus thanks to the bank that Melissa became owner of Great Oak Court, already subject to that charge. She was therefore enriched at the expense of the bank because the value of the property to Melissa was considerably greater than it would have been but for the avoidance of the charge, and the bank was left without security, which was central to the whole arrangements. Then he says at paragraph 25, an important passage, as he sees it, the two arrangements were not separate, but part of one scheme which involved the bank throughout. Then he makes the point in paragraph 26, which echoes the point that Lord Justice Floyd had made in the Court of Appeal below. It's not in dispute that if the bank had received all the proceeds of sale of Rush Green Hall and had then re-advanced the monies required for the purchase of Great Oak Court, it would be entitled to succeed whether or not the re-advance was to the Menelaw parents or to Melissa. Submitted on behalf of the bank that if it is so, it would be pure formalism for subrogation to be precluded simply because the money remained in Bolter's client account and were not paid to the respondent between the sale of Rush Green Hall and the purchase of Great Oak Court. And as Lord Steyn commented in Banque Financière, it would be pure formalism for the interposition of Mr. Herzig between the loan by BFC of its advance and Park's obligation to repay to be treated as altering the substance of the transaction and the result of the claim. He goes on at 127, I would accept those submissions, and then he goes on to set out his suggested approach to when there is a sufficient link to say that enrichment is at the expense of a claimant, whether a particular enrichment is at the expense of a claimant depends on the facts of the case. The question in each case is whether there is a sufficient causal connection in the sense of a sufficient nexus or link between the loss to the bank and the benefit received by the defendant, here, Melissa. And at 28 to 31, he discusses the approach of Henderson at first instance. And at 33, he agrees with the approach of the Court of Appeal. Then the other judgment we need to turn to is the judgment of my Lord Neuberger at 1748. You point out, my Lord, at 61 that a claim in unjust enrichment requires one to address the four questions which Lord Clark had set out. So they are the four questions now that traditionally govern the approach you take. Was it enrichment? Was it the expense of the claimant? Was it unjust? Are there defences? So earlier at 58, you point out that the bank's primary case involves two steps. The first step is that it has a claim based on unjust enrichment against Melissa, and the second step is the claim was or should be satisfied by subrogating the bank to the lien. And it's the first step that's relevant here, and you deal with the question of at the expense of, the second question at paragraph 65. And you point out at 66 that the bank had the right to demand the whole of the proceeds of sale of Rush Green because the parent's debt to the bank exceeded the proceeds of sale, but instead they agreed that the proceeds should be used to fund the purchase of the freehold, provided the bank was granted a charge. So the bank would have had the right to prevent the 875,000 being used to purchase the freehold if it had not been provided with a valid charge. Accordingly, plain that Melissa's enrichment was at the expense of the bank, and you say at 67 that that conclusion is reinforced by the point made by Lord Clark, that it's appropriate to the present case to treat the sale of Rush Green Hall and the purchase of Great Oak Court as one scheme, at least for present purposes. Now, although it's dealt with then under the third question, where it's unjust, Your Lordship does refer again in an important passage at 73 you address there the question of whether a problem is caused by virtue of Melissa being an indirect recipient of any enrichment. And you say that, as already explained above, there was in reality a single transaction, and it was from that transaction that Melissa directly benefited, even though the benefit was effected at the direction of Menelal parents. The benefit to Melissa was direct because it arose as the immediate and inevitable result of the very transaction to which she was party and which gave rise to the unjust enrichment, in contrast, the example given in Professor Mitchell McFarlane's article. I should add that even if Melissa could be characterised as an indirect recipient of any enrichment, I do not consider it would assist her. She would still probably be liable on the facts of this case, essentially for the same reasons. And that's the point I made.
Yeah, as I recall it, and bearing in mind how I put it at the beginning of that paragraph, I think I was slightly on a frolic of my own in the sense that I'm not sure that point was argued, actually. So maybe it was a bit dangerous. But anyway, that's what I said.
Yeah. But if I can, that was the point I was alluding to
Yeah.
in answer to my Lord Reed's point earlier on about characterising it as a direct benefit or not. I mean, here, whether it was my Lord Berger on a follow of his own, the analysis seems to be here is as a result of it being the immediate and every result of the very transaction to which he was a party, you can regard her as being effectively a direct recipient, not an indirect one. But even if you can't, the same reasons should give you a claim against her, even if she is an indirect recipient.
It suggests that the terms direct and indirect
Yes.
are rather unsatisfactory tools.
Yes,
Because what's important here is that there was one scheme,
yes,
and Melissa benefited from that as was intended
yes,
Yeah.
by everyone.
yes. In that sense, in one sense, it's similar to the RELFO. I mean, it's not nefarious, but you've got this scheme which inevitably involves getting it to, in the end,
Yes.
to the knowledge of all the parties to the scheme.
Yeah.
Okay, well, that was a guided tour, which I hope wasn't too long and not too confused, of the present cases.
That's very helpful, thank you.
Can I then stand back and make some submissions about where I suggest we've got to? And the first submission I want to make is that we do question whether or not the, as Lord Justice Moses put it, fuzzy concept of economic reality can provide a sufficiently rigorous tool for determining the boundaries of when an indirect enrichment is to be regarded as at the expense of a claimant. And I note that although it is right to say that there was general approval given by Lord Clarke in Menlo and the Supreme Court to the decision, the judgment of Lord Justice Henderson below, you won't find any explicit analysis making reference to commercial reality, unless you regard commercial reality as being nothing more than another way of putting the fact it doesn't make any difference point. And in my submission, that's not necessarily right. And I've already pointed out when looking at the decision at first instance that Mr. Justice Henderson noted that where the boundaries of this more generous version of reality should be drawn
Correct.
is unclear.
So you say, at best, that concept needs refinement.
Yes.
Yep.
And it's a point we make, my Lord, in our case, in paragraph 17.
Thank you.
We say that once you introduce a concept of economic reality into the equation, you are potentially on a slippery slope. The example we give, if you look at paragraph 17, which is at electronic document number 139,
Yeah?
we make the point that the revenue in this case has been prepared to admit in the case that VAT was passed on to the investment trust because VAT was included in an invoice. And indeed, that's enough to make the suppliers, the managers liable to pay VAT. But if you really do look at the position from the point of view of economic reality, in economic terms, it's much more difficult to know how much VAT is actually being passed on. We all know that you can go into Pret-a-Manger, for example, the day after a VAT increase or decrease has been made, to find the coffee costs just the same. They just charge what the market will bear and adjust the proportion of VAT to the appropriate percentage. Working out in economic terms how much in VAT is actually passed on, as opposed to what the VAT says, are two different questions. And it's a point actually made, my lords, in an opinion of Advocate General Mancini, when he says it's almost never possible to say with any given certainty how much a given portion of price is solely due to the payment of a charge in the same amount. It's only when supply is elastic and demand is rigid.
Your point is it comes back to the fact they don't have to charge VAT. Therefore, you can't say as a matter of law
Yes.
that and for the reason you give an economic reality, that 20%, or rather
Yes.
120ths is
Exactly.
VAT.
Yes. Could I just clarify one point? It may be of no importance, but
Not 20, 100.
Is the VAT invoice critical for giving rise to a liability to VAT in British law? The VAT is charged on the supply.
Yes.
And the time of supply of services is when they're performed.
Yes.
A VAT invoice obviously is critical for accounting
Yes.
purposes and evidence of input tax and so on. But does the liability tax occur at the moment of supply prior to the issue of the invoice, unlike in some other VAT systems? Can I leave that with you
Yes.
for answering later?
Yes. Yes, Martin.
It's just that there was an earlier exchange with Lord Mance, which I may have misunderstood.
It's actually, funnily enough, my lord, it's a point made by the investment trusts themselves. You go to page 63 of the core volume. It follows that when VAT is wrongly levied, this is paragraph 3, the person left in the pocket is more often than not the end consumer, at whose expense HMRC have been unjustly enriched. They footnote, it is possible that the price charged by the supplier is such that in economic terms it is he and not his customer who shoulders the VAT charge, but that is atypical and was in any event not the case here. But whether it's atypical or not, it doesn't alter the fact that if your lordships are going to endorse the per Lord Justice Moses fuzzy concept of economic reality as the appropriate test, it potentially does give rise to considerably additional complications than have so far been viewed in determining in a VAT case the measure of an enrichment. Second point. Let me show you an interesting contribution made by Dr. Wilmot Smith of All Souls in commenting upon this case, and we can get this from document number 2648 in volume 5 of the authorities.
What's the reference again?
2648.
2648.
Tab 62.
It's tab 62.
That's 2644 if it's tab 62. I see, but it's that 2648 in that tab. I beg your pardon. Yep, I see. Thank you.
It's a false reference, my lord, I'm sorry. It is
No, it does include 2648.
Yes.
You may well be right. I'm sorry.
Yeah. 2648 is where, in fact, 2647 is the bit where he starts dealing with the point I wanted to show
The link.
your lordships. And if we start up at the 1/3 the way down 2647,
Thank you.
so if there's to be a connection between the parties such that the defendant can be held responsible to the claimant, it seems that it must be at the expense stage. What connection will suffice to link the two? The formulation in the cases are replete with circularity. For instance, in Menelau, Lord Justice Floyd said there must be a sufficiently close causal connection between the claimant's detriment and the defendant's benefit. And in Relfo, Lady Justice Arden said there must be a sufficient link between the facts, these facts. But it's a tautology to say the link must be sufficient. This is really making the point that my Lord Reed made earlier on. The question remains, what connection is sufficient? And he says, before we can answer that, we need to know what kind of connection we seek. As the quote from Menelau illustrates, the recent Court of Appeal cases have tentatively endorsed a causation. Mere causation of gain is, however, not only insufficient for liability, it is normatively inert. If I mistakenly destroy an asset I own, and this causes your asset to increase in value, I cannot claim restitution against you despite the clear causal link between loss and gain. It is not just that there are good reasons to prevent claims in such factual situations, there is simply no reason for restitution at all. Instead, the law of unjust enrichment is often concerned with reversing defective transfers. Discussion of whether these can be direct or indirect always assumes there must be a transfer. It may well be that there are a number of distinct types of claim that lie beneath the banner of unjust enrichment. That's relevant to a point we didn't go on to. This also explains why there is no liability when there is bare causality. In other words, the example of destroying the asset. There is no transfer of value from me to you when I destroy my asset. The change in value occurs to the operation of a market is in economic terms a pecuniary externality. It also explains the bulk of judicial reasoning, if not always the results, in the Court of Appeal cases. For instance, in Menelaus, Lord Justice Floyd insisted there was a transfer of value from claimant to defendant. And Lord Justice Floyd said that although the case involved an indirect recipient, it was equivalent to a direct payment. In other words, they view the intermediate party as no more than a sham. Again, that echoes a point that my Lord Reed made earlier on, rather like agency. There was thus a transfer from the claimant to the defendant, notwithstanding the money passed through the third party's hands. Many will protest that this requirement that there be a defective transfer between the claimant and the defendant is too vague to be capable of application in concrete cases. We cannot and should not expect legal concepts to determine every possible case. Nevertheless, some progress can be made if it is accepted that the point of the at the expense of requirement is to link the claimant to the defendant and that the requisite link is a defective transfer from the claimant to the defendant. And then he goes back to this particular case and applies the concept of effective transfer, and he comes up with two hypotheses, one of which we could ignore, which was that the VAT wasn't lawfully due under the contract. And he says, on the latter construction, that is, on the assumption that the investment trusts were liable under their contracts to pay VAT to the managers, there is a defect in the transfer from the claimants to the managers because payment was made pursuant to non-existent obligation, and then in the payment from the managers to the revenue because payment was made pursuant to an unlawful obligation. But on neither analysis is there a defective transfer from the trusts to the revenue. They are simply two separate defective transfers. The temptation to recognise a transfer from the claimants to the revenue arises because the money was initially paid with the intention of the managers passing it on to the revenue, but this cannot turn two transfers into one. And with respect to the concept of economic reality and also a test of sufficiently close connection, we respectfully suggest there's a lot of force in Dr. Wilmot Smith's point that sufficiently close connection simply begs the question. What you need to look for is some qualitative link, and a transfer of value between the claimant and defendant gives you a handle, a qualitative link. There's still a question of judgment in determining whether or not that test is satisfied, but it makes some progress that you don't get from sufficient causal connection. And in our submission, that explanation that Dr. Wilmot Smith gives does explain why there is a transfer of value that's sufficiently close link in Relfo in Menelaus. It clearly can be regarded as a transfer of value as between the claimant and the defendant when the route was nothing more than a preconceived plan between the parties to get the value from the former to the latter. Likewise in Menelaus, where the bank was not only in the position to prevent the transfer of funds to Melissa by refusing to release the charge, but the only reason it wasn't a direct payment from the bank was because of the commercial convenience of leaving it in the solicitor's client account. So as Lord Clark put it, the arrangements were not separate and part of one scheme, and as my Lord Neuberger put it, there was in reality a single transaction from which Melissa directly benefited. But in our submission, if transfer of value is the test, for the reason that Dr. Wilmot Smith gives, we don't satisfy it in this particular case. Now, third point, which is, I suggest that somewhat tentatively, but the third point I make is this. Whichever test you choose to apply, the fact does remain that this case is very far indeed from the sorts of situation shown by Menelaus and Relfo, where a sufficient causal connection is established. This is not a case where the revenue could have required the investment trusts to pay them VAT directly, as the bank could have required the mortgage monies to be paid directly, but rather than have it paid to the revenue directly, they let them pay the managers instead for reasons of convenience. This is not a case like this. There was no question of the investment trusts ever paying VAT to the Revenue Direct. The structure of the scheme is it's the managers are liable to account, and they can choose whether to pass it on to the investment trusts or not. Nor, for the same reason, was there any prearranged plan between the investment trusts and the revenue for the investment trust to pay the managers instead of paying the Revenue Direct, as in Relfo. Again, it's just a case of the managers accounting to the revenue and the investment trust paying managers in the ordinary way. And so we say that we do respectfully advance as a possible test the transfer of value test, but even if you're not ultimately convinced by that, the facts of this case is very different indeed from Relfo and Menelaw, where the close connection was established. The only case that begins remotely to justify in our submission holding the causal link is satisfied is the TfL management case. And I'd respectfully suggest that's not a case upon which your lordships should feel happy placing too much weight.
Can I just pause for a moment to make sure I'm understanding this all right? The starting point of a claim in unjust enrichment is a transfer of value, whether it's in the form of money or services or whatever it might be, which is defective in the sense that there is some unjust factor which affects the transfer. And here, as I understand it, you're asking us to say that we in reality we have two transfers which are defective for different reasons. But we have a transfer in the first place by the consumer to the managers, which is a payment under contract, which is defective because the contract in fixing a price inclusive of VAT is affected by a mistake. And so there is a restitutionary remedy available to the customer as against the manager because of a mistake vitiating the contract. And then you have a second transfer from the manager to HMRC, which is payment in accordance with a statutory obligation, and the unjust factor there is the reality that under EU law the statute is inapplicable. Yeah, so two different transfers with two different unjust factors.
I respectfully agree with that analysis. I think, strictly speaking, it would be possible to argue that independently of the unlawful under EU law reason for vitiating the transfer, it could be possible to analyse it as being a mistake as well.
Yes.
But the difference between the investment trust and the manager is the manager would have a claim for recovery regardless of relying upon a mistake cause of action.
Yes. Yes, you're quite right, because it needn't be a Woolwich claim, it could be simply a mistake of law claim.
My fourth and final point on causation and connection is that this case actually goes beyond all the others for another further reason, which is the point we summarise in paragraphs 19 to 21 of our case.
19 to 21.
At document 140 to 142.
Thank you. Yes.
And the point we make there is this, that in all the other cases we've been looking at, a but-for test of causation was made out on the facts. In Menelaw, but for the release of the charges, Melissa couldn't have got the money. In Relfo, but for the payment out of Relfo, Velsani was not to have got any money. Even in TfL, if Explorer's getting the judgment with some kind of benefit for the assignor, the benefit would not have been obtained but for that particular judgment. But as I pointed out when we looked at Relfo and showed you paragraph 72 of Lady Justice Arden's judgment, she said that liability and unjust enrichment requires more than a but-for test to be satisfied, where a claimant contends that the defendant was enriched at the claimant's expense through the intervention of third parties. But if you go to paragraph 71 of Miss Justice Henderson's decision at document number 328,
Yeah. Which paragraph?
Paragraph 71.
Thank you.
The last sentence of that paragraph in our submission is quite critical. It cannot even be said that the VAT was paid or accounted for to the revenue out of the money paid by the claimants and the managers, or that the VAT would not have been paid but for the payments by the claimants to the managers. And the same point is picked up earlier on in the bundle by the Court of Appeal at document number 253.
Yep, page 253, yep.
Paragraph 45 of the judgment.
Thank you. Yes.
Where at paragraph 45, as the judge recognised, there is no strict causal connection between the payment of the VAT on the services and the manager's duty to account. The latter provides the mechanism of recovery of the tax and operates regardless of whether the VAT is due contractually between consumer and supplier or whether it's paid. And so if one stands back and actually asks what's happening in this particular case, this is not a case in our submission where economic reality is being used to reinforce a but-for connection to establish the necessary close link for you to be able to say that the enrichment is at the expense of the claimant. It's actually using economic reality to try and forge a causal connection, notwithstanding the absence of satisfying a but-for test of causation. And in our respectful submission, that's a step too far. 2 steps too far.
Yes.
Now, in our written case, at paragraphs 22 to 29, we make a number of additional points about the problems that can be caused, potentially, by allowing an action by an indirect recipient, against an indirect recipient by a party, at the same time as an action by the person who paid the indirect recipient directly. And most of the points there are self-explanatory. But can I just emphasise 2 particular points before finishing up on this first issue? The first point I want to mention is the point we make in paragraph 24 of the case, which is at 143. We suppose a situation in which a company's been accounting to the revenue for VAT, which turns out was not lawfully due under EU law. But we point out, and this is common ground, that it's perfectly entitled to opt to rely upon the national law until national law is changed, so that the company can decide it still wants to continue to pay VAT in accordance with domestic law, so that it continues to claim reimbursement in respect of that input tax, and so does not make a claim under Section 80. If many customers claim that the VAT is not due under EU law and bring their own direct claims against the revenue end up, therefore, having to reimburse the suppliers many customers on the hypothesis that the VAT was not properly due, while allowing the taxpayer to continue to account for VAT so as to claim deduction for input tax.
That's legitimate, is it? I mean, VAT being a European tax, you're entitled, are you, to continue to operate at domestic scale?
Yes. Well, the reason is, my lord, because the way in which the European law operates is it prevents the state from setting up against the taxpayer an obligation to pay tax under national law that's inconsistently with directly enforceable European law. But the taxpayer, him or herself, is perfectly free to say, until you change national law, I'm entitled to rely upon national law allowing me to pay VAT on this supply.
There are no European consequences in this. I mean,
Well, I mean, let me show you VDP Dental Laboratory. Let's go to
226, yeah.
yeah. Well, in actual fact, my lord, perhaps we can come to that if we need to, but the reason why I mention this is because I think effectively this is common ground.
Yes.
Because if you go to document number 193, which is the respondent's case.
Yep.
Paragraph 40, subparagraph 5, this is directly responding to us. Further, so far as concerns the scenario posited by the revenue in their written case, in which A, the end consumer seeks to recover the VAT unlawfully levied by the revenue, while B, the supplier opts to continue to account for VAT and recover input tax in respect of
Yes, I see.
his supply, the issue identified by the revenue arises in part at least from factors other than the possibility of indirect claims by end consumers.
Yep.
It arises from the principle the state cannot rely on the direct effect of EU law against individuals.
Yep.
It's these elements that give rise to the situation in which a supplier can adopt a position vis-à-vis revenue, which is different from that taken by his customers. So they're saying, well, c'est la vie. That's just simply to do with European law. But it doesn't alter the fact that it's the recognition, if you do so, of the direct claim against the revenue by the customers that does risk giving rise to this paradox that wouldn't otherwise arise.
Yeah.
Next discrete point, leapfrogging. I mentioned when we looked at the four considerations which Mr. Justice Henderson identified as matters relevant to whether or not you recognise a claim against an indirect recipient, which has all then been approved and blessed by the succeeding Court of Appeal cases. I mentioned, if you remember, that leapfrogging, the concept of leapfrogging, the term leapfrogging, was the brainchild of the late Professor Birks. Now, I'd like to show you how Professor Birks dealt with leapfrogging in his seminal work, which is in Bundle 5, and it's at document number 2560, the relevant page.
I'm sorry, could you give me the reference again?
Yes, it's 2560 in Authorities Bundle 5 at tab 56.
Yes.
Um, 2559, there's this is in fact, my lord, his famous work Unjust Enrichment, second edition, which is at 2542.
Yeah.
Leapfrogging. There's no absolute bar against leapfrogging at the very start, but look at the last paragraph before initially valid contracts. The picture seems to be that there is one common case in which leapfrogging is ruled out. For the rest, the policy of the law is not hostile to leapfrogging. It leaves remote recipients to protection of normal defences. The exception, initially valid contracts. Going over the page, 2560, leapfrogging out of an initially valid contract is not allowed. One may never attack one's contractual counterparty's immediate enrichee. Simple model is an unsecured loan. If a bank extends overdraft facility to a customer, and the customer thus has funds enough to give £1,000 to his son, the bank will have no recourse against the son. If the father becomes insolvent, the bank will have to line up with the other unsecured creditors. One reason we're not allowing the bank to sue the son is precisely that the bank must not wriggle around the risk of insolvency inherent in its contract with the father. Contracts entail the risk of insolvency. So what Professor Birks was thinking of with the concept of leapfrogging, which you weren't allowed to do in the case of initially valid contracts, is the minute you allow leapfrogging over a valid contract, you potentially disturb the allocation of risk in the case of an insolvency. Rather than the payor suing the immediate enrichee, who can recover from the the person he paid to, which results in the recovery from the ultimate recipient being used for the general purposes of the creditors. If you give the direct claim against the indirect richee and leapfrogging out of the contract, indirectly you get priority in insolvency. And Professor Burke says, therefore, as a general rule, the law says you can't leapfrog out of a valid contract. Now, of course, that is precisely what the Court of Appeal and Mr. Justice Henderson allowed to happen in this case, because the VAT was paid pursuant to the invoices under initially valid contracts with the managers. So that, my lord, is all I wanted to say.
Well, is at the end of it, the VAT wasn't itself valid. I think that's the point that was being made, and I mean, the contract, no doubt, but the whole point is that the VAT element of the transaction was not valid in the sense that it was not properly chargeable.
Well, I mean, my lord, that may explain why the VAT wasn't, upon a proper construction of the contract, validly chargeable, which is why the existence of the contract didn't prevent the investment trusts having a claim for recovery for mistake against the managers, contrary to the normal situation where you wouldn't be able to claim mistake in the context of the contract. Right. But the fact that that is true doesn't alter the fact that you are still leapfrogging over the valid contract.
Yeah. Yeah, but yes, yeah.
That's all I wanted to say, my lords, in relation to the first issue. Can we turn to the second issue, which is the question of whether or not, even if there is a claim in unjust enrichment, it's precluded by Section 80, and in particular 80 subsection 7. Now, before I show you the provisions in Section 80, can I start by summarising and showing you a couple of cases, summarising what, in my submission, are the relevant principles that govern how you approach this question. It's not rocket science, but it's important to get it clear, particularly in relation to one issue which affected the Court of Appeal's decision, which is Parliament could have intended to exclude this cause of action because no one knew about it at the time.
Yes.
Proposition 1. Most obviously, and this is common ground, the question of whether or not a statute displaces or supersedes a common law right or remedy is a question of statutory construction. They say that in Woolwich Equitable, page 168G to 170D, document numbers 2478 to 2480. It's also said in Deutsche, Morgan Grenfell, but it's so obvious that...
We can't see what else it could be.
Yeah, exactly.
Yeah.
Second point, but this is more important. In ascertaining what Parliament intended, the Court's attention is not confined to giving a literal interpretation of what the words say. The Court's task is effective Parliament's purpose, and critically, because of what's referred to as the always speaking nature of a statute, that can extend to something which did not even exist when Parliament enacted the statute.
Yeah, that's plainly right. Yeah.
And there's a very interesting discussion of how this works and what the appropriate test is in the Quinterval case, which I'd like briefly to show your lordships because it's very important. And that's in volume 4 of the authorities at tab 46, and the starting page by way of document reference is 1840.
Thank you. Where do you want us to look in that case?
Can I just get it up myself? It's paragraph 8 on 1848. But let me just briefly tell you how the issue came up in that case. The question that came up in this particular case was whether, for the purposes of the Human Fertilisation and Embryology Act 1990, an embryo could include organisms created by cell nuclear replacement. which wasn't something that involved fertilisation, when at the time that the Act was passed, embryos could only ever be produced by fertilisation. And the question was, did that preclude it coming within the scope of the Act? And it's really the judgments of Lord Bingham, with whom all the other lords agree, that it's useful to have a quick look at. Starting with paragraph 8. The basic task of the court was ascertain and give effect to the true meaning of what Parliament has said in the enactment to be construed, but that is not to say that attention should be confined and literary interpretation given to the particular revisions which give rise to difficulty. Goes on to point out that not only encourages immense prolixity, it may also, under the banner of loyalty to the will of Parliament, lead to the frustration of that will. And then he deals with the always speaking issue, paragraph 9. No, sorry, let me just finish off at the bottom of paragraph 8. The court's task, within the permissible bounds of interpretation, is to give effect to Parliament's purpose. So the controversial provision should be read in the context of the statute as a whole, and the statute as a whole should be read in the historical context of the situation which led to its enactment. Paragraph 9. There is, I think, no inconsistency between the rule that statutory language retains the meaning it had when Parliament used it and the rule that a statute is always speaking. If Parliament had, however long ago, passed an act applicable to dogs, it could not properly be interpreted to apply to cats, but it could properly be held to apply to animals which were not regarded as dogs when the act was passed, but are so regarded now. And he makes the same point in relation to cruel and unusual punishments, which have changed over time.
Slightly odd.
I'm not sure that's necessarily right.
Not wholly persuasive if Parliament passed an act saying that all cats shall now be deemed dogs, whether some previous statute, or maybe.
Anyway, whether or not your lordships like the analogy that Lord Bingham drew, as he put it, more pertinent is the guidance given by the late Lord Wilberforce in what was then a dissenting opinion in the Royal College of Nursing case,
Yes.
as to when the approach you test, you apply. And that's over the page at 1849. In interpreting an Act of Parliament, it is proper and indeed necessary to have regard to the state of affairs existing and known by Parliament to be existing at the time. It is a bare presumption that Parliament's policy or intention is directed to that state of affairs.
It really is.
Leaving aside cases of omission by inadvertence, this not being such a case, when a new state of affairs or a fresh set of facts bearing upon policy comes into existence, the courts have to consider whether they fall within the parliamentary intention. They may be held to do so. One, I interpolate, if they fall within the same genus of facts as those to which the express policy has been formulated. Or two, they may also be held to do so where there can be detected a clear purpose in the legislation which can only be fulfilled if the extension is made.
Okay.
He then goes on, however liberally the principles may be applied must depend upon the nature of the enactment, the strictness or otherwise of the words in which it has been expressed. They should be less willing to extend express meanings. It's clear that the Act in question was designed to be restricted or circumscribed in its operation rather than liberal or permissive. They will be much less willing to do so where the subject matter is different in kind or dimension from that for which legislation was passed. And then he goes on also to say that they cannot fill gaps. They cannot fill gaps. They cannot be asking the question, what would Parliament have done in this current case, not being one in contemplation, if the facts have been before it, attempt themselves to supply the answer, if the answer is not to be found in the terms of the Act itself. So what we rely upon are the two tests in the earlier part of the passage, that what you have to have in mind is whether or not you can say that new facts fall within the same genus of the facts as those to which the express policy has been formulated, or whether you can detect in the statute a clear purpose that can only be fulfilled if the extension is made.
Yep, thank you.
And then the third and final point is that not only can a common law provision be displaced by an express exclusion, it can also be excluded even by implication.
Yes.
And although ours isn't a case of implication, I just want to show you the test that's applied because it's quite pertinent in this area. Very shortly, in the Monroe Revenue and Customs case, which is in Bundle 3 at tab 43, document number 1770. I mean, briefly, my lords, the facts in this case are that it was a Taxes Management Act. So the Taxes Management Act 1970, Section 33, provides a statutory regime for recovering excessive income tax or capital gains tax paid under an assessment in error. There was no provision providing that revenue, there was provision rather providing that, there was a series of provisions that had to be satisfied in order to bring yourself within a claim for recovery of income tax or capital gains tax paid under an error. It was a defence where payment was made in accordance with the practice generally prevailing, and there was also a 6-year limitation period. But there was no express exclusion along the lines of Section 87 in this case. It turns out, however, that somebody who'd been paying capital gains tax by mistake, but he'd been paying it in accordance with the generally accepted practice, seeks therefore to get around the provision that prevents you having a claim if the mistake was in accordance with generally accepted practice by suing in unjust enrichment instead. And not surprisingly in our submission, the Court of Appeals said no, and the way in which it was put in terms of the test you applied by Lady Justice Arden can be seen quite shortly and succinctly from paragraph 22 at page 1787.
Yep.
The learned Lady Justice says, in my judgment, the authorities give clear guidance that if Parliament creates a right which is inconsistent with the right given by the common law, that it is displaced. By inconsistent, I mean that the statutory remedy has some restriction in it which reflects some policy rule of the statute, which is a cardinal feature of the statute. In those circumstances, the likely implication of the statute in the absence of contradiction is that the statutory remedy is an exclusive one. So, they are the principles which I asked your lordships to keep in mind when we now turn to Section 80 of the VAT Act, which is in Bundle 1 and starts at document number 533. In a Herculean effort of completeness, those who've assembled this bundle for your lordship's delectation have included every single version of Section 80 covering different periods. Your lordship needn't worry about that unless there's some point that Mr. Rabinovic wants to make upon the different versions. The relevant Section 80 for our purposes, which both parties have been working from, is the one that starts at 533. And the reason...
Probably the relevant one is the one that starts, the next one, at 539. That's the one that the learned judge at first instance relied upon. If we're here dealing with whether or not a claim by the consumer should be excluded, then the relevant version would be the one which was in existence at the time the consumer brought a claim. The version that the learned friend was going to take you to is the version that was in existence when the manager made his Section 80 claim. And it's easy to see why, in a sense, both are relevant, but to different points which arise. If you're looking at Section 87, the later one is relevant. I should say the only difference between the two is that the limitation period in the later one is 4 years as compared to 3 years in the earlier one. But in all other respects, the words are identical.
Right. I'm very grateful for that. I don't disagree with that at all. Can I, though, with Mr. Rabinovic's indulgence and Lordship's indulgence, seeing as I've marked up the one that was relevant when the manager brought the claim and not the one that Mr. Rabinovic is referring to, can I take you to the references to 533 and following, but ask your lordships to note that when we get to the relevant provision at 4 on 535, you should write in 4 rather than 3.
Very well.
So, quick run through structure of Section 8.
Where should we write in 4 rather than 3?
Subsection 7.
No, subsection 4, my
Four.
lord,
Subsection 4.
535, 1/3 of the way down.
Yep. Just before 4ZA.
Yeah.
just before 4.
Oh, I see, yes, I'm with you,
Yep.
thank you.
Section 81 is the section that provides that where a person has accounted to the commissioners of VAT, the commission for a prescribed accounting period, but has brought into account output tax an amount that was not output tax due, the commissioners are liable to credit the person that amount. 1A is dealing with the situation where there's been an assessment which is brought into account output tax that was not output tax due. Again, liable to credit the person with that amount. 1B is where a person has, for a prescribed accounting period, whenever ended, paid to the commissioners an amount by way of VAT that was not VAT due to them, otherwise as a result of an amount that was not output tax due being brought into account as output tax under 1 or 1A above. And in those circumstances, the commissioners is liable to repay that person. Subsection 2 over the page, this is the section that effectively allows the commissioners to have a set-off against sums due to the commissioners by the taxpayer when the taxpayer reclaims undue output tax. And therefore it's this section, my lord, that has the effect which is common ground of meaning that, assuming the notional figures of £75 and £25, because the £25 have been set against the have been set against the £100 by way of deduction of input tax, when the revenue have to repay the managers, they repay only the 75 because they're entitled to deduct the 25 that was owed to them as a result of the input tax being incorrectly deducted. Section 3 is the unjust enrichment defence. So that's the defence under which, pursuant to regulations that the commissioners make, effectively they've got a defence to repayment at all if it results in the unjust enrichment of the taxpayer by virtue of keeping the VAT that's been paid to them by their customer. And so practically speaking, what the revenue can do is they can say, we will repay VAT to you, subject to undertakings you give to repay to the ultimate consumer, your customer, the VAT that was wrongly invoiced them. And that's what happened in this case. There's also a provision in 3B which deals with a situation in which loss or damage can be taken into account, but that's not relevant for present purposes. Subsection 4, you've then got what was, by the time of this 4-year limitation period, 3-year limitation period when the managers made the claim. And 4ZA then details provisions to determine what the relevant date is. So in A, we can say in the case of a claim by virtue of subsection 1 above, the end of the prescribed accounting period mentioned in that subsection. And D does the same thing in relation to a claim under 1A. (4A) deals with circumstances in which commissioners can assess the taxpayer for amount that's been overpaid or overcredited under 1 or 1A, but then subject, as you can see, to a 2-year limitation period in 4AA. Subsection 6 simply provides for the commissioners to make prescribed regulations for making claims under the section, which in fact they do pursuant to, I think it's section 37 of the VAT regulations. And then finally and critically, we come to subsection 7, except as provided by this section, the commissioners shall not be liable to credit or repay any amount accounted for or paid to them by way of VAT that was not VAT due to them. And so we observe, before I get on to my submissions, we observe that there's certainly no express limit in the section to credits under section 80A, so 81 or 81A, or payments under 81B. It doesn't say anything like, except as provided by this section, the revenue should not be liable to credit a person referred to in subsection 1 or 1A, or repay a person referred to in 1B, any amount accounted for by the person referred to in those sections, or paid by the person referred in those sections.
And that is in contrast to subsection 4.
Indeed, my lord, indeed. The point I'm absolutely right, my lord. And importantly, my lord, unlike section 81A and 1B, which focus upon the identity of the person making the claim, section 87 imposes the exclusion by reference to the liability of the revenue. It's the liability of the revenue that cannot exist except as providing by this section, and that liability is plainly not confined to any particular class of claimant. So while disagreeing with the decision of Mr. Justice Henderson at first instance, did the Court of Appeal feel that this section still allowed the claimant's unjust enrichment claim to succeed? Well, let's take a look at the Court of Appeal judgment. Which is in the core volume, tab 12, subtab 2, document number 238 is where it starts. Where this particular part of the judgment picks up is in paragraph 70 at 263.
Yep.
Now, what they, effectively in my submission, they really decide that the section cannot apply to exclude the common law claim if it exists for two reasons. The first reason is really a combination of 73 and 76. 73, section 87 does not in terms exclude any claims that are not claims under this section. Instead, it places a restriction on the Commissioner's liability to credit or repay any amount accounted for or paid to by them. This is precisely the same language as used in 81 and 82, and in our view must carry the same meaning. So they're saying that you have to construe the words in the same sense because they are part of the same section. And that's a point that Mr. Rabinovitz makes, relying also upon some case law, which I'll come to. And then that's picked up again in paragraph 76, where they focus upon the notion of repayment.
That means impliedly
Yes.
that you must read into them to
Yes.
credit or repay
Yes.
to the person accounting or to the taxpayer.
Yes, exactly,
which is-
exactly.
So essentially they're saying that there's some necessary implication.
Yes.
Yes.
They are, my lord. And I think it also gets some force from the linguistic point. That this is why I take the two paragraphs together. I take paragraph 73 and paragraph 76 together because I think they sort of go hand in hand. In addition to that sort of, they fit together,
Yeah.
therefore must have the same meaning.
Well, it's not a question of the meaning of those words, is it? Because those words are quite wide enough to cover third parties. It's a question of reading words into section 87, isn't it? And, by reference to the earlier sections. That's what's really being done.
Yes, it is, my lord.
So,
But-
but as you fairly say, it's got to be taken with paragraph 76.
Yes, it's got to be taken with paragraph 76 because they do make a linguistic point in relation to repay. Because although your lordship says repay can be capable of...
That's exactly the point they make at the beginning of 76.
Yes, they're saying although the word repay in isolation is obviously capable of describing the satisfaction of any claim for recovery of overpaid or undue tax, the natural meaning of the word, read in context, is the refunding of the tax to the taxpayer. The use of repay merely reflects provisions of 80 subsection 2A. And so they are saying repay
Same.
can in principle include repaying somebody other than the person who paid you. They don't go as far as saying it can't mean that. They just simply say it doesn't look like it means it here when you take the section as a whole. And we, for reasons I'll come on to in a minute, take issue with that. But that's the first basis for overturning.
Why do they say it's a much less natural meaning? Does it come back to their point about it being surprising in paragraph 71?
Yes, I think it comes. They obviously instinctively think it's a surprising conclusion. I mean, funnily enough, they just have different instinct. Mr. Justice Henderson, as I'll show you, thought it was blindingly obvious that this section must exclude the common law claim for reasons we say he was right to do so. But
If you stand back, it's a pretty odd scheme, you would say, if it doesn't.
yes,
Because it means that you're wide open to third-party claims.
well, I mean, actually, my lord, I mean, the bottom line is if there is a cause of action in unjust enrichment by the end consumer, Section 87 goes out the window.
Yeah.
I mean, going back to my Lord Neuberger's question, the other reason why I suspect they regard as not the natural meaning, although it could mean it, is because it's probably tied in also with the purposive issue. Whereas Mr. Justice Henderson took additional comfort from asking the question from a purposive perspective, because he said no one in their right mind could think that Parliament would have said that the taxpayer is subject to all these restrictions, including the 3-year time limits, and yet the consumer, who for these purposes is being regarded as effectively the taxpayer because they bear the burden, is completely exempt from those restrictions. Parliament couldn't have intended that. Whereas the reason why the Court of Appeal disagree with that approach is because, as we can see from 79, 80 and 81, they say that all begs the question. It begs the question as to whether or not the parliamentary draftsman or Parliament had the common law cause of action in mind. How could he have had the common law cause of action in mind when the claims couldn't have been brought because the common law hadn't yet developed that far when this provision was first introduced in 1989?
This submission you're making at the moment is presumably an alternative to your first one, because if you're right on your first submission, there is no common law claim.
Yes.
The customer doesn't pay the tax.
Yes.
So on and so forth. Yeah.
Yes,
But
so
if
this
you're
is-
wrong about that,
It's on the hypothesis that there is such
Lose
a
on
thing.
issue one, yes. I just need to
This is a
issue...
bar.
Exactly. That's right, my lord. And our submission is that Mr. Justice Henderson puts it very well at paragraph 104, at 339, when he says, probably more eloquently and succinctly, what I've just summarised a minute ago. In the middle of paragraph 104, it seems to be inconceivable that Parliament could have intended a more generous regime to be available to the end customers by whom the economic burden of the unlawful tax was actually borne. It would make no sense at all to limit recovery by the tax collector, but to expose the exchequer at the same time to more expensive claims by the real taxpayer. Furthermore, it could not plausibly be suggested that the position of end consumers was somehow overlooked because the section contains a defence of passing on, and as I've already explained, regulations make elaborate provisions for the benefit of repayments to suppliers to be passed on to their customers. It will be wholly inconsistent with this limited and carefully regulated scheme if claims by the end consumer fell outside its scope.
So we have two sharply different judicial approaches to this question.
Yes. Now, let me deal with purposive issue first of all, which is what we deal with in paragraphs 39 to 47 of our case, starting at 149. Some of which covers the case law I've already dealt with. We make the fundamental point that the fact that the cause of action did not exist at the time provision was first enacted in 1989 doesn't mean that Parliament's intention cannot have been to have an exclusive regime which has the effect of excluding that cause of action when it's subsequently invented. because of the always speaking nature of the statute. And if you ask either of Lord Wilberforce's authoritative guidance, as Lord Bingham described it, first question, does the ITC's claim, the investment trust's claim to recover mistakenly paid VAT, fall into the same genus to which the expressed policy has been formulated as a claim to recover it under Section 80? In our submission, the only sensible answer is yes. The fact that it's a common law claim, not a statutory one, and by a third party, not the taxpayer, does not alter the fact that it's a claim to recover money on grounds it was not due as tax, in relation to which Parliament, for understandable policy reasons, has seen fit to impose a time limit. If you ask yourself the second question, can a clear purpose be detected of the legislation, which can only be fulfilled by construing the provision as extending to a new situation? Again, yes, my Lord. Yes is the only sensible answer. If the purpose of Parliament was to protect the Exchequer by imposing a time limit on claims to recover undue tax, it would simply set that at naught to say it applies to the taxpayer, but not the third party. And it's doubly absurd to do that when the whole rationale for giving the third party the cause of action, if they have one in the first place, is that in economic terms, they are the taxpayer. We also note, as a second point, my Lord, that even if there weren't an express exclusion in Section 87, even if it was simply a question of, does this section impliedly exclude any common law claims, we would go so far as to submit plainly yes, applying Lady Justice Arden's test about can you detect some policy which is a cardinal feature of the scheme, plainly yes. The policy of protecting the Exchequer from claims to recover undue tax beyond a limited period. And our submission is that if a statutory regime would be exclusive, even by implication, it would be bizarre if it's rendered not exclusive by an express provision which purports to actually exclude any other remedy. So that's what we say about why the Court of Appeal were incorrect on their purposive approach. As to the significance of the words credit and repay, again, the mere fact that even the Court of Appeal recognised you could construe repay to include a third party we rely upon, but we say even ignoring purposive considerations, when you look at the way in which Section 87 is framed, which focuses upon the liability of the revenue and not a particular person who's making a claim, that liability is perfectly capable of embracing a repayment to someone other than the party who paid the money directly to the revenue. From the revenue's point of view, they are making a repayment of tax, even if they're paying somebody other than the person they got it from. So repay, in our submission, is a perfectly natural word to use. But once you bring into account the purposive considerations, in our submission, the answer must be decisively that repay must have that meaning. And if it's not the most felicitous word to use, perhaps that's not surprising, given that the draftsman may not have had the common law claim in mind at the time because it didn't exist. But that shouldn't be a reason for taking a literal linguistic construction to defeat the parliamentary intention that a purposive construction discloses. Now, the main point, one of the main points that Mr. Rabinovitz makes is the point that the Court of Appeal were attracted to, which is the words in Section 87 must mean the same thing as in 81. So the way in which Mr. Rabinovitz puts his case is Mr. Rabinovitz says Section 81 and Section 87 must be regarded as coterminous. If you fall within Section 80, subsection 1, then you're subject to the exclusion in subsection 87. But if you fall outside Section 80, subsection 1, Section 80, subsection 7 falls away, takes matters no further. and he relies upon some authorities to support that proposition, which actually, when you look at them, do no such thing. And I need to show you those, and then I'm happy to say that will be the end of the second issue, so I'm making good progress in terms of time, I think. The first case is another judgment of my Lord Neuberger of some time ago now. It's the University of Sussex case. And let me show you how they put it, how they put this particular part of the case. Let's go to document number 197 in tab 10 of the core volume.
Yes.
197, yes.
Yes, thank you.
You can see 52, section 80, subsection 1, 80, subsection 7 are coterminous. For those who have a claim falling in 81 or 81b, the claim is by dint of the express wording in 87. The only means of recovering overpaid tax. But then 2, people who don't fall within 81 because they're never accountable for tax fall outside the exclusion. And they say support from that is derived from my Lord Neuberger's judgment in University of Sussex. They spend quite a lot of time devoted to the analysis of that case. They also refer in paragraph 32 by way of footnote to another case in which they say the same thing is true, and where they point out, tweaking our tail, that the revenue didn't even seem to object to the suggestion that there was a common law claim in restitution free from section 80 subsection 7, and then they rely upon Woolwich and DMG. Let me briefly show you why none of those points hold water. The University of Sussex case, first of all, is in bundle 4. Tab 53. This case arose out of an attempt quite late in the day to claim back input tax that hadn't been claimed at the time. From April 1973 to July 1996, 23 years, a University of Sussex, for reasons that seem to have been political, made no attempt to reclaim input tax. But then in November 1996, they submit a claim for the entire 23-year period, and the revenue contend that the claims are time-barred because they're claims for repayment of VAT which was not due under section 80 subsection 1, so that they were subject to the 3-year limitation period under section 84, and also because section 80 subsection 7 makes clear that section 80 is the only gateway for the claim repayment of undue tax. If we go to paragraph 39 of the judgment, we can see the way in which the university say that doesn't work. They say the claim doesn't fall within section 80, which is a mechanism for claiming undue output tax, not underclaimed input tax. And it therefore says that section 80 subsection 1 has got nothing to do with them. The claim is actually made under regulation 29, and happily for them at that stage, there wasn't any 3-year limitation period applicable to a claim under regulation 39. It was introduced a bit later, but didn't affect them. And so they say, with one bound, we're free from the section 80 subsection 4 3-year limitation period. Now, the way in which this is dealt with by my Lord Neuberger can be seen in 57 is a good place to look at it. It is argued on behalf of the university that it can choose to frame its claim in effect either under regulation 29 or under section 80, and that the two are not mutually exclusive. As already indicated to me, it appears to be as a matter of ordinary language. If the claim, however framed, could fall within section 80 subsection 1, then the combined effect of subsections 4 and 7 means that it's simply not open to the university to make a claim for overpayment, for payment or repayment outside Section 80, or therefore to avoid the limitation period laid down by Section 84, in effect, 87 provides that if Section 80 would provide a gateway for making the claim, then the fact there may be another gateway which might not otherwise face difficulty of a time bar limit will not assist the taxpayer. But, and then we need to go to 63, 65 and 69. 63. Ultimately, the most attractive way, at least to my mind, in which the university puts its case, is that there was in fact no overpayment during the 23 years in question. This is based on the contention that the right to deduct input tax in respect of any period only arises when the taxpayer exercises his right to deduct. Indeed, that is Mr. Cordara's analysis of the Tribunal's reasoning in Royal Bank of Scotland. This contention does not depend upon the argument that the university has an unqualified right to claim input at any time. It merely involves saying that if a taxpayer makes a late but valid claim for input tax, which should primarily have been entered into in an earlier return, then the claim takes effect in accordance with its terms, and that payment of VAT in accordance with the earlier return involved no overpayment. This is the crucial sentence. In other words, although the taxpayer could have paid less VAT pursuant to the earlier return if he claimed all his input tax, that fact does not render any of the VAT so paid VAT not due to the commissioners.
It also means you're not claiming a credit or repayment of any amount paid, doesn't it?
Yes.
You're just claiming a separate sum.
Yes. But crucially, what it does mean is that when the output tax was paid, it was tax due.
Right.
And that's critical for the reason...
Yes. Section 87 doesn't apply.
Yeah, 69. Although the provisions of the 1994 Act may be neutral on this issue, if read on their own, read together with the 6th Directive, I believe that the overall effect is in accordance with Mr. Cordara's submission. And therefore, you then get the final conclusion in paragraph 73. In these circumstances, I'm of the view that on the basis the university argument is correct, I do not accept that the effect of Articles 17 and 18 is that the university is always entirely free to claim input tax whenever it wanted, so that any domestic limitation period will be invalid. It also seems to me that the university's primary right was to claim input tax in the return for the periods in respect to which the supplies concerned were respectively actually made. However, I do not consider that its failure to do so results on an analysis of the way in which the relevant legislation is worded, in money, whether one characterises it as VAT or anything else, having been overpaid to the commissioners. Accordingly, I do not consider the claim falls within Section 80, and it therefore follows that the provision of 80 subsection 4 cannot be relied upon by the commissioners. Further, if that is right, the provision of Regulation 29 applies. So,
I've got an idea this case went to the Court of Appeal. Did it? I think. Yes, it did. Yes.
it did, but nothing turns upon this particular analysis. It's this particular case that Mr. Rabinovich relies upon, not the Court of Appeal.
Right, I see, yes. They didn't say anything relevant on this.
No, my lord.
Right, no.
Now, once you understand the basis upon which my Lord Neuberger held that the claim could not fall within Section 81, you can see why Section 87 couldn't possibly apply to the claim to exclude it. It's nothing to do with the fact that Section 80, subsection 7 is coterminous with Section 80, subsection 1. It's all to do with the fact that Section 80, subsection 7 only excludes the revenue's liability to repay VAT in a claim for repayment made on the basis it was not due. But of course, once you accept that the VAT was due, because in the absence of making a deduction for input tax, there is a liability to pay, that's the end of the story. And so the reason why Section 87 has no bite on the facts of a case like this is nothing to do with coterminosity, or whatever the noun might be, but simply because the claim did not fall within the terms of the exclusion, because it was not a claim for the return of undue tax. My Lord, I'm turning to the BT and Revenue Customs case, which will take me not very long, but more than 2 minutes. Would that be a convenient time to...
Convenient moment then, yes. We're doing all right for time.
Yes.
Very well. Thank you very much. We'll resume again at 2 o'clock. Thank you. Court's now adjourned.